Hi students. I'm Miss Nabihar. In this video, we will continue with the exceptional rule under the age of majority. In the exceptional rule, there are several valid contracts that can be entered with a minor. For example, scholarship contract, insurance contract, and necessaries contract. Let's go through one contract by one contract. The first valid contract that a minor can enter into is the contract of scholarship. Section 4 subsection A of the Contracts Amendment Act 1976 stated that no scholarship agreement shall be invalidated on the ground that the scholar is not the age of majority. In brief, the scholarship agreement will not be invalid or void just because the person who received the scholarship is a minor. This can be seen in the case of Government of Malaysia and Gurcharan Singh. He was a minor when he received the scholarship. One of the terms of the scholarship is that he has to serve the government for 5 years. But he breached the contract by only serving for 3 years. The court decided that the contract was valid, even though he entered it when he was a minor. He has breached the contract. So, he has to pay the compensation to the government. Let's move to the second valid contract, which is contract of insurance. It was provided that, under paragraph 4, Schedule 8 of the Financial Services Act 2013, a minor aged 10 to 16 years old can enter into a contract of insurance with the consent of his parent or guardian. Last but not least, the valid contract that can be entered by the minor is the contract for necessaries. What things can be considered necessaries to a minor? Basically, it is anything that is essential to the life of a minor, such as food, shelter, clothes, education, and so on. However, necessary things may vary, as different people require different things. That's why the court has a test to identify whether one thing is a necessary for a minor or not. There are 2 conditions that need to be fulfilled. Firstly, the nature of goods or services supplied. Luxury goods or services are excluded. And secondly, the actual needs of a minor, and his conditions or station in the life. Let us see how the court uses this test in the case of Nash and Inman. A tailor sued a minor, whom he had supplied clothing, including 11 fancy waistcoats on credit, when he was an undergraduate at Cambridge University. The court found that the minor's father had provided sufficient suitable and necessary clothes. Thus, making additional clothing supplied by the tailor is considered a luxury, when the minor has adequately been supplied with such goods. So, when one of the elements in the test is not fulfilled, the contract is not for necessaries, and therefore void. If we compare with the previous case that we learnt, Government of Malaysia and Gurcharan Singh, the scholarship was considered as necessaries. Because it was for the education of the minor, and at that time, the minor needed the money to get into the academy, and completed his education. Before we end the lecture on this topic, there is homework I would like to assign. Please search 2 more examples of a valid contract that can be entered into by the minor. Support your answers with the law in Malaysia and/or legal cases. That's all for today. I hope you learned something new. And thank you for watching this video. See you in the next one.